You're listening to the Valley Current.
Imagine the scene. It is April 1st, 2026. You are inside the Supreme Court of the United States.
Right.
And the atmosphere in that room is always, formal, almost electric, with this quiet, heavy kind of power.
Oh, absolutely. It's a very intimidating space.
Yeah, exactly. But on this specific morning, there's just an entirely different energy. Because for the first time in the entire history of the country, the sitting president of the United States walks into the chamber, sits down in the gallery, and actually watches in person as 9 justices debate a law he signed on his very first day back in office.
I mean, it's just an incredible visual. It's like the ultimate flex of political capital.
Right.
A president doesn't usually go anywhere near oral arguments. They send their solicitor general and they stay far away from the mechanics of the judiciary, just to maintain the separation of powers.
Yeah, you stay in your lane.
Exactly. But being there in the room, physically watching the justices, it was a deliberate, totally unprecedented signal of just how much personal weight he had placed on this single policy.
And 3 months later, he lost. Or, well, at least that's what the headline said. Welcome to the deep dive. We have a massive, just incredibly rich stack of notes to get through today.
It's a huge stack.
It really is. And it's all centered around this phenomenal newsletter published in the summer of 2026 by the Entrepreneur Law Group, or ELG for short.
Right.
Our mission for this deep dive: we are going to completely unpack that historic June 30th, 2026 Supreme Court decision that just sent absolute shockwaves through the political and legal landscape.
Yeah, and we're talking about a moment where, for the third time in just a 4-month span, the Supreme Court basically looked at the president and told him no.
Told him no.
Yeah.
And this time, they were striking down his flagship Day 1 executive order that attempted to unilaterally end birthright citizenship.
If we connect this to the bigger picture, we're really looking at an intersection of constitutional history, rapidly changing global technology, and, the very real, very heavily contested boundaries of executive power. We are going to look at the actual mechanics of how the presidency operates when it clashes with the judiciary.
Now, before we jump into those mechanics, I do need to pause and make something crystal clear for you, the listener.
Very important point here.
Yeah, because the sources you shared contain politically charged topics from both sides of the aisle. We want to be incredibly clear. We aren't taking any sides here. We aren't endorsing any viewpoints or policies.
Right.
Our only job today is to impartially map out the ideas, facts, and legal arguments exactly as they appear in your source material so you can draw your own conclusions.
Exactly. Just the facts.
Okay, business out of the way.
Yeah.
Let's get into the fascinating mechanics of this. Okay, let's unpack this. Usually when we talk about a high-stakes negotiation, there's a certain rhythm to it, right?
Oh, yeah. A very predictable rhythm.
So say you're a real estate developer buying a massive commercial skyscraper. The seller wants $50 million. You walk into the room, you sit down, and you slide a piece of paper across the desk, offering $10 million.
Which is, it's an aggressive lowball.
Super aggressive.
It's an astronomical opening demand that almost feels insulting.
Exactly. It's an extreme opening bid. Nobody at the table actually thinks the building will sell for $10 million. Mm-hmm. But that extreme bid does something vital. It forcefully yanks the center of gravity in the room entirely to one side.
Right. You anchor the negotiation.
You anchor it so far in your direction that even when you inevitably get pushed back, you still end up on way more favorable ground than if you had walked in and offered like $40 million. It is the classic art of the deal strategy.
It really is.
And the ELG newsletter asks this brilliant central question. Is the president using executive orders like an extreme opening bid in a negotiation to see what sticks?
Yeah.
Are these aggressive legal moves the constitutional equivalent of offering $10 million for a $50 million building?
That framing completely changes how you view a loss in court. If you view an executive order as a piece of legislation, a loss at the Supreme Court is a devastating failure.
Right. It's game over.
But if you view it as an opening bid in a long-term negotiation over the shape of American law, then a loss isn't the end of the process. It's just the prompt for a counteroffer.
Oh, wow.
And that is the defining quality of his second term. Are the justices deliberately rejecting his tactics? Or are they just calling balls and strikes case by case and forcing him to keep playing the game?
To understand that, we really have to look at the very specific mechanics of this birthright citizenship case, which is officially titled Trump v. Barbara.
Right.
Let's start right at the beginning. The timeline here is crucial. Day 1 of the president's second term. He signs Executive Order 14160.
Which was a massive deal.
It's huge. This order directs all federal agencies, Immigration and Customs Enforcement, the State Department, everyone, to deny citizenship to children born in the United States if their parents are in the country unlawfully.
Oh.
Or if they're just here on temporary visas like tourist or student visas.
Which is a complete seismic departure from how birthright citizenship has been administered for, well, over a century. No prior president had ever attempted to redefine birthright citizenship by executive decree.
Never.
The assumption has always been that if a baby is born on American soil, they get an American passport, full stop. He went where no other president had dared, knowing full well it would trigger a massive legal war.
And what was the lifespan of this executive order? Exactly 0 days.
0 days.
It was in effect for 0 days. Almost the second the ink was dry on the president's desk, the lawsuits flew. Multiple states, multiple civil rights organizations, various classes of plaintiffs, they sued within hours.
Yeah, it was immediate.
Every single lower court that reviewed the order blocked it instantly. One district court judge went so far as to put it in their ruling that the order was, quote, blatantly unconstitutional.
And this is where the procedural mechanics get really interesting. Normally, when a district court blocks an executive order, the government appeals to a circuit court of appeals.
Right, which takes forever.
Exactly. The circuit court takes months to brief it, hear arguments, issue a ruling. Then the loser appeals to the Supreme Court, which might take another year to decide whether to even take the case. It is a long, grinding slog.
Yeah.
But because of the immense gravity of the constitutional question, I mean, the fact that millions of people's legal status was hanging in the balance, this case was fast-tracked. It bypassed the usual long slog through the appellate courts and went straight to the Supreme Court on a rare procedure known as certiorari before judgment.
Wait, I want to make sure I'm wrapping my head around that. Certiorari before judgment essentially means the Supreme Court looks at the lower court and says, don't even bother arguing this. The stakes are too high. The constitutional question is too fundamental. We're taking this right now.
Precisely. It is the judicial equivalent of the emergency room, pulling a patient straight into surgery, bypassing the waiting room entirely.
Wow.
The Supreme Court recognized that the country could not function in a state of limbo regarding who is and isn't a citizen. Which brings us back to that incredible scene on April 1st.
Wait, the president in the room.
The fast-track process is why he was sitting in the gallery just a few months after signing the order. It was a flagship initiative, moving at warp speed. And on June 30th, the court delivered its answer. The final judgment was 6-3 against the president. They struck down the executive order.
But here is where we really need to put on our math hats, because the ELG newsletter makes a crucial distinction that most of the mainstream headlines just completely missed.
Oh, they totally glossed over it.
They did. The ruling was 6-3 to strike down the order, but it was only 5-4 on the Constitution. I need you to walk us through that paradox because it sounds impossible. How can a decision be 6-3 and 5-4 at the exact same time?
It is a phenomenal paradox, and it is the absolute key to understanding what the administration does next. Think of this Supreme Court ruling not as a single question, but as two questions stacked on top of each other.
Okay, I'm with you.
The first question is simply the bottom line result. Is the president's executive order illegal? Can it stand? On that question, 6 justices said, yes, it's illegal, it cannot stand.
So that's your 6-3 headline. 6 justices say the order is dead, 3 say it survives.
Yes. But then you have to peel back the layer and look at the second question, why is it illegal? What specific law does it break? This is where the majority completely splinters.
Oh, okay.
5 justices, Chief Justice Roberts, along with Justices Sotomayor, Kagan, Jackson, and importantly, Justice Barrett, said the order is illegal because it violates the highest law of the land, the United States Constitution itself, specifically the 14th Amendment.
It's like 6 friends agreeing to leave a restaurant, right? They all walk out the door together, so the vote to leave is 6-0. But if you ask them why they left, 5 of them say, well, we left because the building is on fire.
Exactly.
That's the constitutional violation. It's structural, it's undeniable, it's life or death. Where is the 6th vote coming from?
The 6th vote belongs to Justice Brett Kavanaugh. To use your analogy, he is the friend who left the restaurant because he didn't like the menu.
Okay, that makes sense.
He concurred in the judgment, meaning he agreed the order had to be struck down, making the final tally 6-3 against the president, but he explicitly declined to say it violated the Constitution. He did not want to touch the 14th Amendment.
So what did he base his vote on?
He argued that the executive order violated a federal statute, specifically a citizenship provision first enacted by Congress in the Nationality Act of 1940, which is now codified in modern law as 8 U.S.C. Section 1401A.
Let me make sure I understand the magnitude of Kavanaugh's maneuver here. He's basically saying, look, I'm not going to get into a massive historic fight about what the Constitution means. I don't need to.
Right.
Congress passed a law back in 1940 that laid out the rules for citizenship, and the president's executive order clearly violates that specific law. Therefore, it's illegal. I vote to strike it down, but I am leaving the constitutional question for another day.
You've nailed it. It is a much narrower ground for his ruling. It's a classic judicial restraint move. Don't decide a massive constitutional issue if a smaller statutory issue can resolve the case.
But the three dissenters, Justices Thomas Alito and Gorsuch, how did they see it?
They disagreed with all of them. They looked at both the Constitution and the 1940 statute and said the president's order was perfectly legal under both. They would have upheld the executive order entirely.
Wow.
So when you look at the pure fundamental constitutional question of whether the 14th Amendment guarantees birthright citizenship to the children of undocumented immigrants or temporary visitors, the vote wasn't 6-3. It was a razor-thin 5-4.
I want to zoom in on something you just mentioned, because it completely shatters a very popular, very pervasive narrative about the current Supreme Court.
The rubber stamp idea.
Yes, exactly. If the Supreme Court has a solid, conservative supermajority, and one of the deciding 5 votes to strike this down on constitutional grounds came from Justice Amy Coney Barrett, who was appointed by President Trump himself, doesn't that completely destroy the argument that the court is just a rubber stamp for the administration?
It heavily, heavily undercuts the rubber stamp charge, absolutely. The ELG analysis points this out with great clarity. You have a Trump appointee supplying a decisive, unavoidable vote against him on his signature Day 1 policy. She joined Chief Justice Roberts and the 3 liberal justices in full.
And Chief Justice Roberts actually wrote the majority opinion for those 5 justices, right? I imagine he didn't mince his words.
He was incredibly pointed. He didn't just quietly disagree.
Knowing his track record on institutional integrity, he likely had some pretty sharp language about what citizenship actually guarantees. What exactly did he say?
Roberts wrote, quote, "Citizenship, then and now, was the right to have rights to freely participate in our political community. The framers of the 14th Amendment extended that promise to every free-born person in this land. We keep that promise today."
Wow.
He systematically dismantled the government's arguments, noting that the administration's dramatically revisionist view of the citizenship clause had scant evidence and that it simply, quote, "is not the law."
The right to have rights. That is an incredibly powerful piece of language. It frames citizenship not just as a passport, but as the foundational prerequisite for human dignity within a legal system.
Exactly.
But to truly understand why those 5 justices, including Roberts and Barrett, ruled that the Constitution irrevocably protects birthright citizenship, and why the administration and the 3 dissenting justices argued so fiercely that it doesn't, we have to leave the year 2026 for a minute. We have to travel back 158 years.
We have to go back to the literal ashes of the Civil War.
Right. Let's look at the deep historical foundation here. The 14th Amendment's Citizenship Clause was ratified on July 9th, 1868. And the context of why it was written is absolutely crucial for understanding this 2026 Supreme Court case.
It's everything.
The 14th Amendment was written specifically to overturn one of the darkest moments in Supreme Court history, the infamous Dred Scott decision.
For listeners who might need a refresher, the Dred Scott decision of 1857 was a Supreme Court ruling that declared that Black Americans, whether enslaved or free, could never be considered citizens of the United States.
Yeah, just a horrific ruling.
It was catastrophic. It helped precipitate the Civil War. When the war ended, the victorious North realized that if they just left citizenship up to individual states or even up to regular laws passed by Congress, a future political majority could just come along and strip citizenship away from newly freed slaves all over again.
They realized a regular law wasn't strong enough. They needed to embed it into the bedrock of the country. They wanted to settle the citizenship question once and for all, placing it completely beyond the reach of state legislatures, beyond the reach of future Congresses, and certainly beyond the reach of a single president's executive order.
So they wrote a seemingly simple rule into the Constitution itself.
And the text of the 14th Amendment says, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States."
And subject to the jurisdiction thereof. Those are the 4 hinge words. everything we are talking about today. The executive order, the Supreme Court fight, the future of immigration, it all revolves around the interpretation of those 4 specific words.
And it isn't the first time the Supreme Court has had to interpret those words. The ELG notes point us to a massive foundational precedent from 1898 that wrestled with this exact phrase. It's a case called United States v. Wong Kim Ark.
That case is the Rosetta Stone for modern citizenship law.
Tell us about Wong Kim Ark. Who was he, and why did his life become the anchor for this 2026 decision?
Wong Kim Ark was a man born in San Francisco to Chinese immigrant parents. Now, we have to understand the atmosphere of the late 19th century. This was the era of the Chinese Exclusion Acts.
Right, a really dark period for immigration.
Very. The federal government had explicitly passed racist laws barring Chinese immigrants from ever naturalizing and becoming U.S. citizens. So, Wong Kim Ark's parents were legally forbidden from ever obtaining citizenship.
Okay.
When Wong was a young man, he traveled to China for a visit. When he arrived back at the port in San Francisco and tried to return home, the U.S. government denied him entry. A customs official essentially told him, your parents aren't citizens and they aren't allowed to be citizens, therefore you are not a citizen and you can't come in.
But he was born in San Francisco. He was born on U.S. soil.
Exactly. And Wong Kim Ark fought back. He sued the federal government. The case went all the way up to the Supreme Court. And in an 1898 decision, the court ruled 6-2 in his favor. They held that a child born in the United States to immigrant parents is a citizen by birth under the clear text of the 14th Amendment, regardless of whether the parents were legally eligible for citizenship. The court said the location of the birth, combined with being subject to the law, is what matters. That single 1898 case has been the absolute anchor of U.S. citizenship law ever since.
Okay, let's unpack this carefully. If the text says you have to be born here and subject to the jurisdiction thereof, how in the world do the two sides in this 2026 case look at that phrase and interpret it so differently?
It's wild, isn't it?
Because obviously they're reading the exact same 4 words from the exact same amendment and coming to completely opposite world-altering conclusions.
It all comes down to what the word jurisdiction actually means in a legal sense. The majority view, which is the long-settled view reaffirmed by Chief Justice Roberts, Justice Barrett, and the liberal wing, is that subject to the jurisdiction simply means subject to U.S. law. If you are physically present within the territorial boundaries of the United States, you have to obey the laws of the United States. You are under the jurisdiction of the police, the courts, and the government.
Are there any historical exceptions to that? Because if subject to the law is the only test, it seems pretty cut and dry.
There are exceptions, but they are incredibly narrow and heavily historically defined.
Like what?
The classic example is the children of foreign diplomats. A French ambassador living in Washington, D.C. is legally granted diplomatic immunity. They are not fully subject to U.S. law. If they commit a crime, they are expelled, not tried in a U.S. court.
Right, diplomatic immunity.
Therefore, if the French ambassador has a baby in a D.C. hospital, that baby is not a U.S. citizen because the parents were never subject to the jurisdiction in the first place. Another historical exception is the children of hostile occupying enemy forces.
Sure, that makes sense.
If a foreign army invades and a soldier has a child on occupied U.S. soil, that child isn't a citizen. And historically, there was a very specific exception for Native American tribes.
I saw that referenced heavily in the notes. There is an 1884 case, Elk v. Wilkins.
Yeah.
How did Native American tribes fit into this concept of jurisdiction?
It's a dark and complex piece of constitutional history. In the 1884 case Elk v. Wilkins, a Native American man named John Elk, who was born on a reservation, attempted to register to vote in Nebraska. The Supreme Court ruled against him, holding that he was not a U.S. citizen under the 14th Amendment.
Because of the tribal sovereignty.
Exactly. The court reasoned that Native American tribes were separate, quasi-sovereign nations. Therefore, a person born into a tribe owed immediate allegiance to that tribal nation, not the United States, and was therefore not subject to the jurisdiction of the U.S. government in the way the amendment intended.
Wow.
It actually took a totally separate act of Congress, the Indian Citizenship Act of 1924, to finally confer birthright citizenship on all Native Americans born within the territorial limits of the country.
Wow. So outside of those extremely narrow specific exceptions, foreign diplomats with immunity, hostile invading armies, and historically sovereign tribal nations, the majority's view is that if you are physically here, you are subject to the law. And if you are subject to the law, you are subject to the jurisdiction.
Precisely. That is the Roberts and Barrett view.
Here's where it gets really interesting, because the administration and the three dissenting justices, Thomas, Alito, and Gorsuch, pushed a totally different definition of the word jurisdiction. They argued it doesn't just mean obeying the local laws. They argued it requires something deeper. It requires direct allegiance or legal domicile.
Yes. The dissent's argument is that the children of temporary visitors, like a tourist on a 2-week vacation, or the children of undocumented immigrants, lack that direct, permanent, and immediate allegiance to the United States.
Okay.
They argue that mere physical presence isn't enough to trigger the massive lifelong bond of citizenship. Therefore, those children are not subject to the jurisdiction in the profound, sovereign way the 14th Amendment intended.
But I have to push back on that, or at least ask you to explain the logic, because it feels like there's a massive hole in it.
Let's hear it.
Logically, if jurisdiction just means being subject to the law, nobody argues that an undocumented immigrant is immune from prosecution if they commit a crime on U.S. soil, right?
Right.
If an undocumented parent walks into a bank in Chicago and robs it, the U.S. government has the full, unquestioned jurisdiction to arrest them, try them in a federal court, and put them in a federal prison. They don't get diplomatic immunity. They don't get to say, well, I lack allegiance, therefore you can't arrest me.
That's a great point.
So how does the dissent legally justify this idea that they somehow aren't subject to the jurisdiction when it comes to having a baby, but they are subject to the jurisdiction when it comes to robbing a bank?
It is a profound, deeply researched, originalist argument. Justice Thomas, in his dissent, took on this exact contradiction. He wrote that the majority's view of history, quote, is not historically accurate. The dissenters aren't looking at modern criminal code. They are looking at massive, dusty legal dictionaries from the 1860s. They're reading the transcripts of political debates on the floor of the Senate from 1866.
So they're digging deep into the archives.
Oh, yeah. They argue that in the mid-19th century, the word jurisdiction carried a much heavier, more sovereign weight than just simple police power. They argue it implied a mutual reciprocal relationship. The government provides ultimate protection, and the individual provides ultimate allegiance.
I see.
If someone is only here temporarily or here unlawfully in defiance of the government's borders, the dissent argues that mutual bond of allegiance hasn't been legally formed. You can be subject to police power without being subject to sovereign political jurisdiction.
So they're essentially saying that the 1898 Wong Kim Ark decision, the absolute bedrock of our modern system, got it wrong.
That is exactly what they're saying. And Chief Justice Roberts pointed this out directly in his majority opinion. He noted that this narrow reading of jurisdiction, this allegiance argument pushed by the government, is not new. It was actually raised back in 1898.
Oh, it was?
Yeah, it was the dissenting opinion in Wong Kim Ark. It commanded only a minority of the court back then. It lost in 1898, and Roberts is forcefully saying it loses again now.
But as I read through the ELG notes, the most compelling argument from the dissent didn't actually seem to be about 1860s legal dictionaries or reciprocal allegiance theories.
No, it took a very modern turn.
It did. The newsletter highlights a completely different angle, championed by Justice Alito, and it is absolutely fascinating. It's not a debate about language, it's a debate about technology.
Yeah.
It's about steamships versus airplanes.
This brings us to a really elegant, incredibly thought-provoking framework the ELG newsletter uses. They map U.S. constitutional history onto what they call the 6 industrial revolutions. Once you see this framework, it completely changes how you view Alito's dissent and honestly how you view the law in general.
Walk us through this framework, because it completely blew my mind when I read it. How does the Industrial Revolution connect to birthright citizenship?
Let's trace the evolution of travel technology. In the first Industrial Revolution, which ran roughly from 1760 to 1840, human travel was defined by early steam engines and canals. Crossing the ocean was done by sail, and it took weeks, if not months. It was grueling.
It was a massive undertaking.
Exactly. When the 14th Amendment was actually debated and ratified in 1868, society was moving through the Second Industrial Revolution, the era of expanding railroads, the invention of the telegraph, and the rise of early coal-fired steamships.
Right.
But even then, crossing the Atlantic Ocean on a steamship still took about a week or more. The journey was incredibly rough, the conditions were poor, it was expensive, and frankly, it was dangerous.
So if you were coming to America in 1868, you weren't popping over for the weekend.
Exactly, you were committing. Now, fast forward to today, which the ELG newsletter categorizes as the 6th Industrial Revolution.
Right. The era we are living in right now. The era of artificial intelligence, generative agents, and global commercial jet aviation. Today, crossing the ocean doesn't take a week on a dangerous coal-fired ship.
No, not at all.
It takes a few hours in a pressurized cabin while watching a movie. You can book an intercontinental flight, reserve a luxury hotel, and arrange ground transportation, all from a smartphone while standing in line waiting for a latte. The friction of global movement has essentially dropped to zero.
So how does Justice Alito weave this massive technological shift into a constitutional legal argument? He argues that the framers of the 14th Amendment in 1868 could not possibly have imagined the modern phenomenon of what we call birth tourism.
Birth tourism.
Right. When those men sat in a room and wrote a rule tying U.S. citizenship strictly to physical birth on U.S. soil, they wrote it for a world of slow, arduous steamships. Getting to America to have a baby wasn't something you did casually or temporarily or as a strategic geopolitical move.
It just wasn't possible.
Right. The technology of the 19th century acted as a natural physical filter against casual travel. Alito argues that a constitutional rule designed for the limitations of the steamship era is now being actively exploited in the limitless jet era. Because travel is trivial, people can fly into Miami or Los Angeles on a tourist visa at 8 months pregnant, give birth in a hospital to secure an American passport for the child, and fly out a week later.
He is basically saying you are taking a rigid 19th century law and applying it blindly to a 21st century technological reality.
Yeah.
And in doing so, you are breaking the original intent of the law.
Exactly. He was incredibly stark about it. He called the ruling one of the most important decisions in the history of the court, and in my judgment, the court has made a serious mistake. He warned that the majority's blind adherence to an old precedent was conferring the immense power of American citizenship on virtually everyone who happens to be born in this country, including the children of birth tourists.
It is a genuinely compelling point on a practical level. When the friction of reality changes, shouldn't the law change with it? How did Chief Justice Roberts respond to that technological argument? Because you can't deny that jets exist.
Roberts responded directly from the bench, and his response was a masterclass in judicial philosophy. He looked at the dissent and said, quote, "It's a new world. It's the same Constitution."
Wow. Let that sink in. It's a new world. It's the same Constitution.
The majority's view is that the meaning of the United States Constitution does not automatically update itself just because human travel got faster or because iPhones were invented.
Right.
If a constitutional rule produces consequences today that society doesn't like, if society decides that birth tourism is a critical problem in the jet age, the solution is not for 9 unelected Supreme Court justices to simply reinterpret the words of the 14th Amendment by judicial decree. The solution is for the democratic process to work. The people must amend the document.
It's a fundamental debate about who has the power to adapt the law to modern reality. Does the Supreme Court act as an editor and reinterpret the text? Or does Congress act as a legislature and amend it?
Precisely. And this philosophical debate raises an incredibly important practical question about the actual real-world scale of the problem Justice Alito is so deeply worried about. Just how big is this birth tourism issue? Is it a trickle or is it a flood?
The ELG newsletter pulled the data on this, and the numbers are incredibly revealing, largely because there's such a massive debate over the statistics themselves.
The numbers are all over the place.
They really are. The Niskanen Center, which is a well-known think tank, argues that the true figure for birth tourism is microscopically small. They estimate it is less than 2,000 cases a year. They actually call the anxiety around the issue an egregious overestimate fueled by politics, not reality.
But there are other much higher estimates.
Right. On the higher end of the spectrum, you have the Center for Immigration Studies, which advocates for lower immigration levels. They estimate there could be up to 33,000 births a year to women who come to the U.S. on temporary tourist visas and then leave shortly after.
So we have a fiercely contested range from roughly 2,000 on the low end to 33,000 on the high end.
But let's put those numbers into a broader national perspective. Let's look at the denominator. For scale, the CDC recorded 3,628,934 total U.S. births in the year 2024, over 3.6 million babies born.
Wow.
So even if you take the absolute highest, most aggressive estimate of 33,000 birth tourists, you are still talking about less than 1% of all births in the United States.
It is a statistically rare phenomenon, and yet it is driving a massive constitutional argument that would fundamentally alter the legal status of millions of people who live here permanently.
And as the ELG newsletter points out, there is a deep psychological and cultural element to this anxiety that goes far beyond pure statistics. The newsletter includes this really interesting, almost cinematic footnote, a cultural sidebar.
The TV show reference.
Yes. They talk about how the dissent's allegiance argument isn't just about legal dictionaries. It is fueled by anxieties you see played out in modern pop culture. They mention a specific TV trope referencing a show they playfully call Americans, obviously echoing the critically acclaimed FX series The Americans.
It's a brilliant comparison. The premise of that show is about deep cover foreign intelligence agents, KGB spies during the Cold War, embedding themselves in the United States.
Right, they're the ultimate sleeper agents.
They live in the suburbs, they act like travel agents, they live seemingly perfectly normal American lives, and crucially, they have and raise U.S. citizen children who have absolutely no idea who their parents really are.
Exactly. The fear is that the next generation holds the ultimate prize U.S. citizenship. By birth, meaning they can get security clearances, run for office, or work in the Pentagon, but secretly, deep down, they owe their true allegiance to a hostile foreign power.
It's a terrifying concept.
It is. Now, the newsletter is very careful to clarify that this is a work of fiction. It's a thematic citation to understand the mood, not a factual claim about a real-world espionage network utilizing maternity wards. But it perfectly, vividly illustrates the cultural narrative that's animating the dissent's fear. The fear of infiltration through the innocent exploitation of the 14th Amendment.
Which is an anxiety that is deeply rooted in how the United States compares to the rest of the world. Because the way the United States handles citizenship is not the global standard. We are actually an extreme outlier globally.
Let's talk about that global context because it really reframes the whole debate.
Yeah.
We use a legal system called jus soli, which is Latin for right of the soil. It means unconditional citizenship by birth on the territory, regardless of who your parents are.
But what's absolutely fascinating here is that unconditional jus soli is overwhelmingly, almost exclusively, a Western Hemisphere practice.
I had absolutely no idea about this until I read your source material. I mean, I just assumed every democracy gave citizenship to whoever was born there.
Not at all. It's largely confined to the Americas. The U.S., Canada, Mexico, Brazil, Argentina. There are about 33 countries in the world that grant unconditional citizenship by soil, and they are heavily concentrated in North and South America.
Why is that?
It is a legal tradition deeply tied to the history of the New World. These were massive, expanding nations that needed to encourage rapid immigration, settlement, and the assimilation of incredibly diverse populations into a single national identity.
So what does the rest of the world do? How does Europe or Asia handle it?
The vast majority of the world, most of Europe, Japan, China, India, the Middle East, they use a system called jus sanguinis, which translates to right of blood.
Right of blood.
In those systems, citizenship follows the bloodline of the parents, not the geographic location of the soil. If a French citizen travels to Tokyo and has a baby in a Japanese hospital, that baby is French. They do not automatically become Japanese just because they were born in Tokyo.
And what's even more striking in the notes is that even countries that used to have American-style birthright citizenship have actively gotten rid of it.
Yes, and this is exactly what Justice Alito pointed to. The United Kingdom ended unconditional jus soli back in 1983. Ireland ended it via a massive public referendum in 2004.
Wow, so relatively recently.
Very recently. They didn't just wake up and change it. They changed it specifically to adapt to modern travel and modern immigration pressures. In those countries, they shifted to what is called conditional jus soli, meaning a child born there is only a citizen if at least one parent is already a citizen or at least a permanent legal resident.
Okay, that makes sense.
Justice Alito cited the UK's reversal in his dissent, essentially saying, look at our peer nations. They realize the steamship era is over. They adapted their citizenship laws to the reality of the jet age. Why are we binding ourselves to an outdated interpretation?
So let's look at the totality of the board. The president looked at this landscape. He saw the global norm shifting towards citizenship by blood. He saw the rising cultural anxiety over birth tourism. He looked at a Supreme Court with a solid 6-3 conservative supermajority, and he calculated the odds.
Yeah, he made a bet.
He took an extreme, massive shot at a 158-year-old foundational law by issuing this day one executive order, and he missed. The Supreme Court shot it down. But the crucial question for us is this birthright citizenship case an isolated failure, or is it part of a much larger, more complex pattern of how this president interacts with the judiciary?
That is the multi-million-dollar question of his second term. To answer it, we have to pull back from the 14th Amendment and look at the broader scoreboard.
Let's look at the incredible 3-day span at the very end of June 2026. Or actually, more broadly, let's look at the 4-month span starting in February. The glaring headline of the ELG newsletter is that this birthright decision is the third time in 4 months that the Supreme Court looked the president in the eye and told him no.
Let's recap those 3 rapid-fire losses, because the sequence is stunning.
Okay, in February 2026, the court struck down the president's attempt to impose sweeping universal economic tariffs using an emergency power statute called IEPA. That was a bruising 6-3 loss.
Right.
Then, fast forward to June 29th, just one single day before the birthright ruling. The court ruled 5-4 against the president in a massive case called Trump v. Cook. He had tried to unilaterally fire a sitting Federal Reserve Governor, Lisa Cook, to gain control over monetary policy. And the court stepped in and said, no, you absolutely cannot do that. The Federal Reserve remains an independent entity.
And then, the very next morning, June 30th, the 6-3 loss on birthright citizenship in Trump v. Barber.
3 massive second-term flagship initiatives: tariffs, control of the Fed, and birthright citizenship, completely blocked by the Supreme Court in the span of 4 months. If you only look at that specific cluster of cases, it looks like a total humiliating rejection of the president's agenda by his own hand-picked court.
It absolutely does. But the ELG analysis cautions us strongly against stopping there. It warns against a superficial reading of the headlines. We have to look at the broader second-term ledger.
Because there were wins, too.
Exactly, because while the president suffered those 3 high-profile, extremely visible losses, he also quietly won some of the most consequential structural victories in modern presidential history.
Walk us through the wins. Which cases are we talking about?
Well, the foundational one, the bedrock of his entire second term, is from July 2024. The case is Trump v. United States.
Oh, the immunity case.
Yes, that was the historic 6-3 ruling granting the president sweeping immunity from criminal prosecution for official acts. That ruling structurally insulated the presidency, it removed the threat of personal legal jeopardy, and arguably that immunity is what made everything else he attempted in his second term, like the aggressive executive orders, psychologically and legally possible.
Okay, so a massive paradigm-shifting win right there.
Yes, and even during that brutal late June stretch in 2026, hidden among the losses, he had another huge structural victory. On the exact same day he lost the Federal Reserve case regarding Lisa Cook, June 29th, the court handed down a decision in Trump v. Slaughter.
Okay, what was that one about?
That was a 6-3 ruling that sent an earthquake through administrative law. It overruled a decades-old foundational precedent called Humphrey's executor.
I want to pause here because Humphrey's executor is one of those terms that gets thrown around in law school but needs translation to the rest of us. What did that old case do, and why is overturning it such a big deal?
Humphrey's executor was a case from the 1930s that essentially created the modern independent agency. It said that Congress could create certain government agencies, like the Federal Trade Commission or the SEC, and protect the heads of those agencies from being fired by the president just because the president disagreed with their politics.
So they couldn't just be fired on a whim.
Right.
Yeah.
They could only be fired for cause, like severe malfeasance. It created a layer of government that was somewhat insulated from presidential control. But in Trump v. Slaughter, the conservative majority completely destroyed that insulation. The court ruled that the president does have the absolute constitutional power to fire the head of the Federal Trade Commission at will for any reason.
Okay, wait, let me make sure I have this straight, because this is mind-bending. On June 29th, the court issues a ruling that says, yes, Mr. President, you have the ultimate authority to fire the head of the Federal Trade Commission. But in a totally separate case, decided on the exact same day, they look at him and say, but no, you cannot fire a governor of the Federal Reserve.
Exactly. It seems contradictory, but it's actually highly precise. What's fascinating here is that the court is acting as a meticulous referee, not as a political adversary. They are drawing very specific, highly nuanced constitutional lines.
Wow.
They handed the president massive historic victories, expanding his deep structural power, giving him absolute immunity, giving him the power to decapitate independent agencies like the FTC. But they drew a hard, unyielding line when he tried to bypass Congress on emergency tariffs, when he tried to interfere with the deeply entrenched independence of the central bank, and when he tried to rewrite the 14th Amendment by a stroke of a pen.
It really paints a picture of a court that is fiercely independent, willing to take things strictly on a case-by-case basis. Which is probably why the readers of this ELG newsletter were so intensely, wildly polarized in their reactions.
Oh, the comment section was fascinating.
Yeah. The newsletter included a fascinating section detailing actual reader comments, and the spectrum of opinions is just wild.
They categorize the reader responses into different themes, and it really serves as a mirror for how the broader American public is processing these complex, high-stakes rulings.
Some readers were just purely furious. One wrote, and I quote, "One of the most obvious SCOTUS rulings in history. The fact that it was 6-3 is insane. 3 members of SCOTUS can't read the Constitution."
Wow.
Yeah, that reader is looking at the plain 158-year-old text of the 14th Amendment born in the United States and simply cannot fathom how 3 Supreme Court justices could intellectually twist themselves into a dissent.
But then you have readers on the exact opposite side pointing to the mechanics of how change should happen. One reader commented, quote, "The right way to change this is via a constitutional amendment. I don't see how this is any different." That reader is actually validating Chief Justice Roberts' point. They agree with the conservative goal of ending birthright citizenship, but they acknowledge you can't just decree it from the Oval Office.
There were also comments leaning heavily into the birth tourism and foreign infiltration anxiety we talked about earlier with the Americans TV trope. One reader explicitly mentioned intense fears of Chinese citizens coming to places like Guam to have children who will then, quote, vote according to the CCP in U.S. elections.
Now, the newsletter notes very clearly that while birth tourism does exist in small numbers, that specific framing of a coordinated, multi-generational CCP infiltration plot to manipulate voting demographics is a highly contested political opinion. It is not established fact. But its inclusion in the comments shows just how incredibly potent that cultural narrative is. It's the anxiety that drives the base.
And then there was this final comment, which I thought was the most insightful observation regarding the court itself. A reader wrote, quote, "This should put paid to accusations that the court is in Trump's pocket. There is clear rationale behind all these decisions, and that is the job of the court, to interpret law and not to create it."
And objectively, looking at the data, that reader has a verified point. Trump appointee Barrett joined the liberal wing against him to save birthright citizenship. Trump appointees Gorsuch and Barrett ruled against him to block his emergency tariffs. The court is clearly, undeniably exercising independent judgment.
Which brings me all the way back to my opening analogy about the real estate developer in the boardroom. If a developer asks for double the asking price, knowing full well they will get rejected, just to anchor the negotiation and move the center of gravity, is the president doing the exact same thing with the Supreme Court?
It's a fascinating question.
He issues a blatantly unconstitutional day one order. He knows it will likely get smacked down.
Yeah.
But does the very act of forcing the entire judicial system, the media, and the Supreme Court to fiercely debate the boundaries of birthright citizenship actually move the Overton window? Does the extreme opening bid alter the political landscape even when it loses in court?
That is the pure logic of the deal maker. An anchored negotiation almost always results in a counteroffer. The extreme bid forces everyone at the table to react. It forces the entire system to expend massive amounts of energy responding to your terms.
Right.
So if you adopt that mindset, the practical question isn't just did he lose? The practical question is what happens next. Now that the Supreme Court has ruled, now that the extreme opening bid has been rejected, what are the administration's next moves?
So what does this all mean for the actual future of birthright citizenship? The ELG analysis maps out 4 specific paths the president could take to try and change the rule now that the June 30th decision is officially in the history books. Let's break these 4 paths down.
If you are the president's legal team waking up on July 1st, you have to look at the board. Path 1 was the executive order route.
Status failed. Dead on arrival. 5 justices declared it a fundamental violation of the Constitution. He cannot unilaterally end birthright citizenship with the stroke of a pen.
Right, which means you have to pivot. That brings us to path 2, an act of Congress attempting to pass a brand new federal statute.
And this is where Justice Kavanaugh's lone, incredibly specific concurrence becomes so wildly important. Because remember, Kavanaugh didn't say the Constitution guarantees birthright citizenship. He just said the president violated a 1940 statute.
Exactly.
So almost immediately after the ruling came down, Trump posted on Truth Social explicitly urging Congress to legislate a fix. He's using Kavanaugh's concurrence as a literal roadmap. He's saying to his base, okay, Kavanaugh says it's just a broken statute, so let's have Congress change the statute.
He is attempting to instantaneously pivot the energy from a crushing judicial loss into fresh legislative momentum. It's a brilliant political redirection. But the ELG newsletter points out a massive, likely fatal barrier to this path.
What is the barrier? Because if he controls Congress, couldn't he just force a vote?
even if he controlled Congress, it comes back to the math of the 5-4 constitutional split. Remember, 5 justices, Roberts, Sotomayor, Kagan, Jackson, and Barrett, held that the Constitution itself requires birthright citizenship for these children.
Oh, right.
Because they rooted their decision in the 14th Amendment, any new law passed by Congress attempting to narrow citizenship would face an almost insurmountable barrier. Even if Trump bullied Congress into passing a new law tomorrow, the moment that new law was challenged in court, which would happen in minutes, those exact same 5 justices would look at it and likely strike it down as unconstitutional, because Congress cannot pass a statute that violates the Constitution.
So path 2, an act of Congress, is technically an open avenue for political theater. But legally, it is highly, highly likely to be ruled unconstitutional based on the math we already have. Which leaves path 3, a constitutional amendment. If the Constitution is the problem, just change the Constitution.
Status technically open, but practically, in the real world, near impossible.
I mean, let's look at the mechanics of amending the Constitution. You need a 2/3 supermajority in both the House of Representatives and the Senate just to propose it.
Good luck with that today.
Yeah, and then it has to be sent to the states and ratified by 38 out of the 50 state legislatures. In today's hyper-polarized, gridlock political environment, getting those numbers on something as controversial as citizenship is virtually unthinkable. And frankly, Trump himself knows this.
Yeah.
He has publicly called the amendment route unnecessary.
He doesn't want to spend his precious political capital on a decade-long, bruising, state-by-state amendment fight when he prefers immediate, forceful action. Which brings us to the final option, path 4. And this is the one that is highly actionable right now, today.
Path 4, the administrative lever. This is the practical, quiet route. Explain how this works, because it doesn't require the Supreme Court, it doesn't require Congress, and it doesn't require 38 states.
This is where the power of the modern presidency truly lies.
Yeah.
The administration can use its existing massive executive authority over the vast federal bureaucracy, specifically the State Department and U.S. Citizenship and Immigration Services, or USCIS.
Right.
Without changing the underlying law of citizenship by a single syllable, they can instruct consular officers stationed at U.S. embassies all around the world to drastically tighten visa screening. They can issue new administrative guidance specifically targeting pregnant applicants.
So instead of trying to strip citizenship away from babies after they are already born on U.S. soil, which the Supreme Court just said is unconstitutional, they just create massive administrative walls to prevent pregnant women from ever entering the country in the first place.
Yes.
They cite the prevention of birth tourism as the official reason, and they just deny the visas at the source.
Exactly. It's an administrative chokehold. Consular officers have immense, almost unreviewable discretion when deciding who gets a tourist visa. If the State Department issues guidance saying, scrutinize all pregnant applicants for intent to engage in birth tourism, the denial rates will skyrocket.
Wow.
It doesn't alter the text of the 14th Amendment, but it practically, effectively achieves a massive portion of the administration's policy goal by utilizing the mundane levers of the bureaucracy.
So what does this all mean for you, the listener, as you watch this unfold? I think it synthesizes down to this. While the front pages of the newspapers are going to scream about a massive, humiliating presidential defeat at the Supreme Court, 3 brutal losses in 4 months, the dealmaker's method survives.
It adapts.
It adapts. Anchor high, absorb the counteroffer, and redirect the energy. He lost the executive order at the Supreme Court, but he immediately redirected the political focus to Congress, and he still has the quiet, powerful administrative levers at his absolute disposal to choke off immigration at the embassies. The underlying law of citizenship hasn't actually changed today. A baby born on U.S. soil today is a U.S. citizen, full stop.
That's the law.
But the boundaries of executive power, the limits of what a president can try, are being aggressively mapped, tested, pushed, and redefined in real time.
It is a relentless stress test of the American constitutional system, led by a president who treats constitutional litigation exactly like a real estate negotiation.
It really is. The extreme opening bid might get dramatically rejected by the judge, but the negotiation itself is far from over.
Which leaves us with a final, incredibly provocative thought drawn directly from the ELG newsletter's introspective questions. We saw that when the president lost the massive emergency powers tariff case at the Supreme Court in February, he didn't give up. He simply turned around, found a different statute, and reimposed those exact same tariffs under a completely different law within a matter of hours. So, if losing in the highest court in the land simply redirects this president rather than actually stopping him, what would actually count as a binding limit, and have we even seen one yet?
That is the profound question that is going to define the rest of this term and likely the future of the presidency itself. Thank you so much for joining us on this deep dive into the mechanics of power. Led by Jack Russo, Computer Law Group LLP is a bespoke business litigation and founder-friendly boutique law firm with offices and licensed attorneys in Silicon Valley, New York, and Tampa Bay. And you can reach Jack at computerlaw.com and his team at www.computerlaw.com, where the newsletter we refer to is published in detail and readily available commitment-free with no paywalls or other charges.
Tune in next time on The Valley Current.